Welcome to Frank Bruno Law, elder law attorney. I'm going to give you a little snapshot into the day that I had. It started this morning that I was on a virtual court appearance. It was a pretrial conference. I then had a client come to the office concerned about her case, and I did other work and some written assignments, and then I finished up with a consultation with an adult son and parents. So, elder law affects people typically of an older age, right? Maybe the AARP measure, or our senior population at about 62 and older. And it affects people across a broad spectrum of cases. So the case that I was on this morning was a divorce. I represent a person as a special guardian. I was court appointed to represent an individual. The individual had been in the middle of a divorce. Someone in the court proceeding, right, another attorney involved, identified and brought to the court's attention that this individual needed a guardian. And then after the divorce had been put on hold, the guardianship judge appointed me to be the special guardian for this individual. And that's because I have divorce experience and guardianship experience. So that was the beginning of my day. I then had a client that my office is assisting, an elderly woman that is the owner of a two-family home. So during the pandemic, she became, she had an issue with her tenant, and we are processing an eviction for her. So I have an associate that does evictions, but I handled the consult initially, and often enough I'm the go-between the office and this particular client. And there's been a moratorium in place. Things have been held up, held in abeyance in the landlord-tenant realm. And as of right now, should the moratorium not be extended, and it's been extended a number of times, at the end of August it will expire, and then September 1 we can file. So in an eviction takes place, I'll break it down simply. It's a two-step process. You need to serve the predicate notice. That's the if it's a holdover, you give a certain amount of time. If the person failed to make payments, rent payments, it's a non-payment case. In this instance, the tenant did in fact not pay rent. However, we're not going in with that cause of action. What we're doing is a holdover proceeding, and that predicate notice was served, and it was able to be served. And then just a couple of weeks ago, my office had served on the tenant a hardship declaration. So what that means is something new that came about as a result of the pandemic. If the landlord has to serve this hardship application upon the tenant, and if the tenant has in fact a hardship, they can fill it out, and certain circumstances will take place in the case, right? I don't actually know what they will be. The length of time, held in abeyance, I don't know. Still a work in progress, right? For me and for everyone else handling this area of law at this time. But this existing client came in because she had to sign an affidavit saying that the tenant did not return the hardship application, saying that there was a hardship. So that's why she was in. very difficult to really accept and comprehend that the pandemic has changed so many things in our lives, including causing a landlord the inability to go forward and reclaim a part of their property. So we just have to push on, push, and continue. Stay safe, be well. Please check out the website, frankbrunolaw.com.